Good morning and welcome to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. I am located at 1563 Main Street in Peckville, Pennsylvania, and I am right here with you 8 to 9 a.m. right here in this station each and every Sunday morning to bring you, the landowner, the royalty owner, the information you need regarding oil and gas development in Pennsylvania. At the Clark Law Firm, and here it comes, I represent Pennsylvania landowners and royalty owners. I do not, I have not, and I will not represent gas or pipeline companies. Never have, never will. I represent the landowner, the royalty right owner, for such items as, of course, gas lease negotiations, reviews, consultations, royalty issues, breach of gas lease issues, damages issues related to oil and gas development, surface use agreements, pipeline agreements, water line agreements, meter site agreements, well pad agreements, releases, unitization issues, on and on and on, roadways, any and all issues related to oil and gas development, buying and selling property, buying and selling gas rights. I'm doing more and more estate planning issues or estate planning for clients and landowners, royalty owners, making sure that your plan is specific to you and it meets your specific needs, not your neighbor's needs. As you hear me say all the time, and it's just so true, that today is a lot different than it was 10 years ago. You need specific advice for you and your circumstances. The days where people were just going on the internet and just copying or finding addendums, getting them from neighbors, piecing them together and presenting them to the company when there's a bunch of companies trying to fight for leases, well, that could work in cases. Those days are gone. It is so much more nuanced. Detailed information, education on these issues is absolutely critical. Unitization issues. Have you been unitized properly? Is the company developing properly? New lease offers are much more nuanced. We need to understand a lot more of detail than what we did or what we needed to know when there wasn't this development. But now there is development. Now there's more information that we're looking at. Now there's a lot more leases signed. There's many more factors, different factors, much more complex factors than just which company do I sign for? Let me throw this addendum at the company and see what happens. It is a different world out there. And you need to make sure that you're getting someone who's going to guide you properly, effectively, and knowledgeably through these issues. Somebody working for you. Of course, that's what I do. But if you don't call me, you have to call someone. And we got to stop. I'll keep saying this. So be prepared. I will keep saying this over and over because it's happening all the time. We need to stop relying on the company landman to educate you as the landowner. That company landman is working for the company. You should not be educated about your rights, your leverage, your ability to negotiate money, your ability to negotiate better terms by the other side. By the other side. That should not be happening. Yes, we can get information. Yes, we want to hear what they want to do. Yes, there can be value to this. But there's a limitation to the value. There is a limitation to the value that you can receive when you're talking to a company landman or company representative because they're on the other side of this process. So you need somebody who's experienced and knowledgeable and has gone through these processes before to help and assist you. You need to have that. War story. Over the past week, a landowner calls, has an offer for a unique project. The offer, I'll put it this way. Within a week, it says, okay, hey, I think I'm going to sign this. This is great. Just want you to look at it. Say, whoa, wait a second. Let's go over this. We're doing a review and consultation and say, hey, look, I really think there's some more compensation that you may be able to obtain here. And approximately a week later, a little bit more, I think we went more than doubled what the agreement was when it was presented that the gentleman was going to sign. Think about that. Just if it was a $50,000 agreement, I'm not going to get real specific. Now it's $100,000. Or if it was $100,000, now it's a $200,000. And that was based on a call to find out that person's rights, to understand the document. Oh, and by the way, we're changing the document significantly, the language of the document, to make it much more landowner friendly. So we're going to preserve the property as much as possible, minimize the impact, minimize future abilities of the company to add additional lines, to put things above ground, different things like that. We need to look at the full picture. And in this case, thankfully, this person called for review and consultation, which then led to some more work, but ultimately led to more than doubling the compensation and a much better agreement. Now, that doesn't happen every day, but it happens a lot. Increases happen in terms, in compensation regularly. Whether you call me or call someone, you need to be calling someone before you agree to compensation, and certainly, obviously, before you sign anything. And people aren't doing that, and people, I assure you, are being taken advantage of. Not just a little bit, but a lot. People are being taken advantage of, and unfortunately, we are doing it to ourselves. The landowners are doing it to themselves. We need to stop that. We need to stop that. We need to stop being so trusting of these energy companies who, you have to understand, they say it's a partnership, but in reality, their goal is to maximize profits for the company and for the shareholders. Their goal is not to be your partner. Their partners, representatives, fiduciaries of the shareholders. That's their job. Don't fall into the trap that, oh, the landman, he's my friend, he's fighting for me, he's trying to do everything for me. Well, you're not paying him. The company is paying him. Never, ever forget that. Never, ever forget that. You're listening to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. You can join me right here in this station every Sunday from 8 to 9 a.m. And real quick, with Susquehanna County landowners who are receiving these multi-unit well consent requests from Cabot, give us a call and learn about the reviews and consultation services. You need, in my opinion, specific advice for you, and what's right for you may not be right for literally your next door neighbor. So give us a call, 570-307-0702. That's the Cabot multi-unit well consent request. Give us a call, see if we can help you. 570-307-0702. And of course, any other oil and gas related matter, 570-307-0702. Okay, we got a lot to talk about today. But before I get into some of the more detailed stuff, I want to say, this has happened twice. Actually, twice in the last week and a half, but 3 times probably in the last 3 weeks. People call the office. They're engaging in a transaction to sell property and gas rights, or to sell property or sell gas rights, and sometimes selling property, keeping the gas rights, sometimes just selling gas rights. So it's a buy-sell transaction of property and gas rights in a combination of either keeping them, selling them, whatever that may be. The problem that I am seeing, and I'm seeing it repeatedly, is people are signing sales agreement contracts to sell their property and gas rights, or gas rights. They're signing sales agreements often presented by realtors or the attorney for the other side. They're signing those agreements. Those agreements can be very, very complicated, and they have hidden loopholes and poison pills often inserted throughout these agreements. You should not, my opinion, you must not sign sales agreements unless you have them reviewed by your attorney, by an attorney. I've seen it, like I say, it's driving me crazy because I've had multiple people in the last 2 weeks call me and say, hey, will you look at this? Hey, will you look at this? And they send it, and it's already signed. So I can look at it and say, well, here's all the different problems that are in this agreement. This is a very bad agreement for you, in my opinion. You're listening to All Things Marcellus with me, Attorney Doug Clark. It's a bad sales agreement. But there ain't a darn thing I can do about it now because your signature is on this document already. Why? I say, why? Why didn't you send me this before you signed it? It would have taken less than an hour. Look at it. We could have talked and said, hey, look, this is bad. You need to change this. You need to change that. I'm telling you, 3 of these in the last 2 weeks, week and a half, last 2 weeks. And it just leaves me scratching my head. Why? You need to stop signing sales agreements for property and gas rights. You need to stop signing before you go to your attorney. You need these reviewed. They are very bad. Many of them. I mean, some I guess could be good, but the ones I've seen recently aren't. And you have to be careful. Think about it. If the other side's attorney is drawing up this sales agreement, how favorable is it going to be to the other side? If the other side's realtor is drawing up the sales agreement, how favorable may that be? And your realtor, no offense, realtor, your realtor is probably not an attorney. They're a realtor. They also have a commission at stake. So perhaps, again, don't want to disparage realtors, but let's just pretend there might be a bad one. And maybe that person really wants the sale to go through because they're going to make a commission. You need to have these documents reviewed by your lawyer to make sure you're doing what you think you're doing. Because the last 3 I saw, that was not the case. But there was a signature on the bottom by the client who asked me to review it. And once it's signed, there is little to probably nothing you can do about it. You don't have something reviewed after you sign it, like a sales agreement. Now, you can enter into a gas lease or pipeline agreement and later say, hey, look, I need to understand this. Again, you should be doing that before you sign. But if you need to understand something, that's one thing. But guys, we have to stop signing bad agreements and have them reviewed before you sign. To understand your leverage, the loopholes, the poison pills that may be in there, the escape routes for the other side, the potential additional compensation in certain agreements, and ways to make this language much more fair, more even, and frankly, better for you and your side. And you need to do that before you pick up the pen. And we're talking about sales agreement. That's the same thing as a lease, or not. It's not the same thing, but it's the same concept with the lease, with a pipeline agreement, water line agreement, well agreement, any of those things. Same principle. Stop signing bad agreements. Pick up the phone, call us, call somebody that knows what they're doing, learn about what your rights are, become educated in that document, and see if there's something you can do. I don't know that I've ever seen a sales agreement that I said, oh, hey, that's great, go ahead and sign it. And I've seen a lot that I think have major problems. And we correct those. And not saying I'm magical. They can be corrected. You just have to know what you're doing, and you have to correct them. So stop signing bad agreements. Call before you sign. Even if it's a sales agreement, you can do a review and consultation. Call before you sign. Don't make that mistake. All right. We're up against it here. You're listening to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. Remember, Susquehanna County residents, area landowners, Cabot multi-unit well requests, give us a call, doing reviews and consultations. My opinion, do not just simply sign these documents. They are very powerful, in my opinion. You're given something that says, hey, here's what we plan to do, but there's no guarantee that's what occurs. Look at the map. It says preliminary, subject to change. Look at this stuff and see, what may happen after I sign this document? And what may happen is probably quite a bit different than what you're thinking. So you should be getting specific advice for your situation. Everyone should. Stop signing bad agreements. Get specific advice. Also, more and more pipeline projects coming online here are starting in Susquehanna, Bradford, those areas, Wyoming. Give us a call. Any of these matters. 570-307-0702. Again, Doug Clark, 570-307-0702. And make sure you're tuning in each and every week for All Things Marcellus from 8 to 9 a.m. right here in this station. And I'll be right back after this break. Welcome back to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm, where I represent landowners and only landowners, royalty owners. And make sure you join me every Sunday right here in this station from 8 to 9 for All Things Marcellus. And to the Susquehanna County residents who are getting multi-unit well request consent forms, mouthful, Cabot sending out multi-unit well consent requests. My advice, do not simply sign these documents. This is my general advice, not specific advice for any individual, but my general advice is don't sign and get help. Get a review and consultation. I'm doing them all the time. Get them from somebody else. If there's somebody else that knows what they're doing and you're more comfortable, call someone else, but call someone. These are powerful documents that will apply as presented for the lifetime of the lease for decades and decades and decades. In my opinion, as a general rule, people should not be simply signing these documents. I'll explain more. I'm going to talk more about this later in the show. But boy, if you get these, love to hear from you. See if we can help you. See if we can do a review and consultation for you. It usually takes an hour to two tops. 570-307-0702. I do all the reviews and consultations. So you can come in the office, sit down, speak with me, go over it. Or we can do it by telephone. But give us a call. 570-307-0702. Okay, the first thing I want to talk about today, and I don't think it'll be a long discussion, but I want to talk about arbitration provisions or terms which require arbitration in gas leases primarily, but you see these in other documents as well. In my opinion, we want to stay away from mandatory arbitration provisions in oil and gas leases. That is now, we have learned, a priority to stay away when at all possible from mandatory arbitration provisions. These provisions are very powerful and beneficial to the companies. Why are they there? Well, the companies are offering them because the company likes them. Then they say, hey, land guy, when you go out there, tell the landowner that, hey, this arbitration provision is really good for you because it keeps costs down. It won't cost as much in lawyer fees. It won't cost as much in discovery. It'll be quicker, and everyone's going to do better. This will be great. arbitration's wonderful for you and the company's just a nice guy or a nice thing. So it's presented that way. But the reality is quite a bit different. Well, they say, you know what? All right, company, that's really nice of you. That's really nice of you. But you know what? I'm going to pass on that. I'm going to pass. I know, and it shouldn't be a problem, I would think, that I'm going to pass on this because you're telling me how great it is for me. So if I want to turn down something that's supposedly positive for me, that shouldn't be a problem for you as the company. But hear how they respond. Now, maybe they say, oh, okay, sure. But more likely, they're going to say no. And it's really funny to watch, to me it is anyway, any person say, well, okay, what about this arbitration provision? This is great for you, landowner. This is what you want. It's going to be quicker. It's going to be cheaper. It's going to be great. It's good for you. Great, great, great. Well, you know what? I appreciate that, but I'm really not interested in that. I don't like the arbitration provision. I'd like to keep that out. Well, you know, the company wants to keep that in. Well, if it's so great for me, why does the company want to keep that in? Well, because, guess why? It's not so great for you. It's actually enormously great for the company. Wonderful for the company. Because it essentially, still fighting out there, but really what it probably means is that the company has prevented them from being exposed by groups of landowners or a class of landowners suing them simultaneously. So you have to go individually after the company in each and every case that you may have in your lease. Let me give you the example. You're listening to All Things Marcellus with me, attorney Doug Clark of the Clark Law Firm. You have a royalty issue against the company. You say, you know what? This company, maybe they're taking deductions that they shouldn't be taking. Maybe they're not paying me the price on the gas that I think they should be taking. Maybe they have drilled a vertical well on my property and not used my pad, and now we're going to reclaim it and go drill somewhere else. So maybe you think you have a claim against the company. And in fact, maybe, have a hypothetical, you have an excellent claim, we'll say. Say it's an excellent claim against the company. But you only have 10 acres of property. Not that that's small acreage, but you have 10 acres of property. So when you look at, we'll keep our hypothetical to a royalty issue. And let's say that we find out, I'm going to make this real simple, again, hypothetical, that we can determine that every month the company is paying you royalties, and we can determine, again, this is a hypothetical, that we feel that you're being shortchanged royalties every month in the flat amount of $1,000. Again, we're making this up for simplicity, easy numbers. So each month we say, hey, company, you're paying me royalties, but each month I'm being shortchanged by $1,000. So over the course of a year, that's $1,200. And then you talk to your neighbor, and they say, you know what? I have 10 acres too, and the same thing's happening. And sure enough, people start in the community talking, and that's happening everywhere and everywhere. So let's pretend, so it's $100. You have 10 acres, and you're being shortchanged $1,000 a month. That would be $100 for each acre. So let's say, again, we're making this up, but we determine that a gas company in a certain area is paying everybody per acre $100 less than what they should. So we have, again, a great case, we're saying. We have a great case against the company. All right, I have 10 acres, so it's only $1,200 a year. I'm going to sue the company. Well, how are you going to do that? It's going to cost a lot of money. It's going to cost a lot of money to sue the company. You're going to have to pay for your lawyers. You're going to have to maybe have experts. You're going to have fees, all of these different expenses. So again, well, maybe arbitration sounds good. Except when you go to arbitration, you're typically going to have 3 arbitrators, which means you and the other side have to pay for the arbitrators. So you have to pay for your attorney. You have to pay for the 3 arbitrators, and then, of course, any other discovery expense, experts expense, things like that. Those get very expensive. You don't have to pay for a judge. When you have your case in a court system, you don't write a check and pay for the judge's time. That's important. Don't be fooled into arbitration being cheaper. Some of these arbitrators can cost, and this is not an exaggeration, $5,000 to $10,000 a day. And you have 3 of them. That gets pretty expensive. But that's not the reason why you really want to stay away from arbitrations, in my opinion. This is All Things Marcellus. You're listening to me, Attorney Doug Clark, and make sure you join me every Sunday from 8 to 9 a.m. on this station, and give us a call for representation, information, reviews and consultations, multi-unit well issues, 570-307-0702. 570-307-0702. Okay, so we're talking about arbitrations, and my general statement, again, remember, none of this to show or anything I say is specific advice for any individual. They're my feelings. They're general advice across the board, but not specific advice for anyone. My general advice, and especially in oil and gas leases, is do all you can to avoid arbitration provisions. Over the course of the last 10 years, case law has changed, and now it looks extremely difficult and possibly impossible to group together to go after a gas company as a group of landowners or a class of landowners. That is unbelievably valuable to the company. You know, if you think about arbitration provisions and you wonder, you're told how good they are, well, go pull out your credit card statements or your credit card agreement. Go pull out your bank agreement. Go pull out any of those agreements, and you'll see that they all have mandatory arbitration provisions. And the reason is divide and conquer. Divide and conquer, or another way to look at it is any claim that you have as a credit card holder, as a person at a bank, or a person as a banking individual, or as a lessor on an oil and gas lease, those claims are going to have to be brought through arbitration, and generally speaking, it would be on an individual basis. So if you have, again, back to my example, if we can establish that this is again hypothetical, that every month a gas company in a certain region is shortchanging royalty payments by $100 per acre. We can establish that. Again, this is a hypothetical, not aware of this situation, but this is an illustration for an example. So each month it's $100 shortchange per acre. So if you have 10 acres over the course of the year, so that would be $1,000 per month. Over the course of the year, that would be $12,000. So we want to sue the gas company. Well, if we're going to sue them in arbitration, we're going to bring a claim. There's going to be 3 arbitrators. We're going to have to pay all of their fees. We're going to have to pay whatever our attorney fees, expert costs, litigation fees, document fees, all these different fees that are going to come into play. Well, as you may imagine, $12,000 to cover all of those fees is not actually going to do it. So you're going to need a bigger claim to justify going into arbitration. So you say, well, maybe I'll wait 2 years and let this stuff stack up. And so now if it was $12,000 in the first year, now it's $24,000. Well, same scenario. It's probably, now I'm not, it's going to be tough to bring a claim in arbitration. $24,000 is a lot of money, but there are a lot of costs and fees that have to be paid to go through this process. Remember, you have to pay 3 arbitrators who are generally attorneys or judges, and those fees are going to be expensive. They can go from a few thousand up to $10,000 a day per arbitrator. So you're going to need a pretty big claim to advance if you're going through arbitration. This is Attorney Doug Clark. You're listening to All Things Marcellus. Remember to join me each week at this time on this station. So you're going to need a big claim, a claim that's going to justify the expense to go into arbitration. Well, unless you have a lot of acreage, unless you have, there's no magic number, 50, 100, 200, whatever that number is, because it'll depend upon the size of the claim. So you need to have a large enough claim, a large enough money at stake to go after the company in arbitration. And of course, we're saying, hey, we think this is a guaranteed winner. I mean, there are, in my opinion, virtually no guaranteed winners. So you don't even know if you're going to win. And then if you do win, also, you're going to have to pay your attorney if you entered into a contingent agreement with them, or you're paying them hourly. And if you lose, that's going to be pretty ugly. So arbitrations can be really bad. Well, why do the companies like them? Well, we're up against it here. I'll explain it in the next section. Stay with us. So remember, we want to get arbitration provisions out as a general rule, not specific advice, but general rule. And we're going to talk more. We're going to talk about why companies love arbitration provisions. Love, love, love. When we get back after this break. You're listening to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. Remember, Susquehanna County area landowners, pipelines, anything, you name it. But right now, a hot issue is the multi-unit well consent forms being sent out by Cabot. My opinion, you should not be simply signing those and returning them. You should be at least, in my opinion, limiting the language and potentially not signing. You need to look and find your specific case and how it matters to you and how it will apply to you. And it does not necessarily apply the same to you as it does your neighbor. There are many different people within a very close proximity who have totally different interests in these documents. Don't fall into the trap. Get specific advice from someone who knows what they are doing. This can be very complex, very, very complex. You need specific advice. It is complex. Give us a call. It usually takes an hour or two, and I don't know if any has ever taken more than 2 hours of reviews and consultations for multi-unit well consent requests. 570-307-0702. 570-307-0702. Give us a call. Love to hear from you. See if we can help you out. I'll be right back after this break. Welcome back to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. I'm going to jump into a bit just real quick. Susquehanna County landowners, if you have a multi-unit well consent request sent to you by Cabot, my advice, give us a call. Give somebody a call. They can be, and I believe are, very complicated, despite how they look. And that's the value of review and consultation, because your position may not be the same as other people. And that's what you need, is specific advice. So I'd love to hear from you. 570-307-0702. Also doing more pipeline work in the area. Some projects are heating up. Give us a call, 570-307-0702. Okay, so we're talking about arbitration provisions. Again, let me just reset quickly. Couple points. As a general rule, my strong, and I mean strong, opinion is avoid arbitration of provisions in oil and gas leases as much as you possibly can. I'll say it again. My position, my opinion, is to avoid arbitration provisions in oil and gas leases. The companies will tell you how much they are to your benefit. Then you say, well, great. Then there should be no problem getting rid of it, because you should be happy that I'm not taking something that you say is beneficial to me. Therefore, if I ask to get rid of it, it must be beneficial to you, and you should not object to that. So I personally would take an or ask to remove an arbitration provision when the company says, well, we don't want to do it. So, well, you told us how important it was and how valuable it was to me as the landowner. I don't understand now why you would not allow me to get rid of something that's so important. Well, the reason why is because actually the arbitration provision, in my opinion, is highly, highly beneficial. Could be hundreds of millions of dollars of benefit to the gas company. Again, let me repeat that. Could be hundreds of millions and even into the billions of dollars benefit to the company. And why do I say that? Because arbitration clauses can be, and it looks like may be, a complete block to class actions on behalf of landowners. And class actions, the value of class actions is when you have a whole bunch of people that have smaller claims that you can't individually bring against the company because they're too small for each individual to bring. But collectively, if everyone joined together, now the claims, the amount of controversy, the money involved, if you pull it all together from all the people, all the landowners, and all the leases that are affected, and you go after the company, now you got their attention. Now they have an issue because all these guys that have a $10,000 a year claim, who they know probably can never bring that claim because it's not cost effective, even though that's a lot of money. It's probably not a claim that people are going to bring because it's not cost effective. It's not enough money to justify going through the arbitration process and all the expenses that occur through that process. So when you divide all of these people that have smaller claims, most people aren't going to bring those claims, and therefore the company is never sued, and they may have actually breached the contract and they may be in the wrong. But if they're only in the wrong, say $10,000 a year, then maybe they don't get sued, or they certainly don't get sued by a lot of people, in which case they keep that $10,000. So that's very beneficial to the company. You're listening to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. Make sure you tune in every Sunday, 8 to 9 a.m. right here on this station and give us a call. Reviews, consultations, multi-unit well requests, you name it, pipelines, anything. 570-307-0702. 570-307-0702. Okay, arbitrations. Again now, I had given a hypothetical that we're saying that, again, I stress, this is a total hypothetical to illustrate a point, that we can determine that each month a gas company is shortchanging the landowner by $100 of royalties every month for each acre that landowner owns. So if a landowner owns 1 acre, each month they are being shortchanged $100. So they're not going to go and sue the gas company because over the course of the year, they're being shortchanged by $100 a month, or a total of $1,200 during the year. Now, if the landowner has 10 acres, well, $100 per acre per month, they would be shortchanged $1,000 per month. Well, over the course of the year, 12 months, $1,000 per month, that landowner would be shortchanged a total of $12,000 in that year. Very good chance that's also not enough to justify bringing a lawsuit against the company. So what happens is, and that's through arbitration. So if you did not have arbitration and you could go after the company as a class or a group of landowners that were impacted, now you can bring everybody together. Every half acre guy, every 1 acre, 5, 10, 15, 20, every person who has that same issue can join together and be very powerful against the company. The company can't divide and conquer you and force you to go to individual arbitrations in each and every case. And when they do that, that's a great victory, because if there is claims, everybody with a small claim is not going to bring that claim, because there's a mandatory arbitration provision in your lease, which requires you to go to arbitration, which requires 3 arbitrators, which requires you to share the cost or pay 1/2 the cost of these arbitrators, which often can go into the tens of thousands of dollars, depending on the case, depending upon the arbitrators. Some arbitrators are $5,000 to $10,000 a day. If you had 3 arbitrators at $10,000 a day, each day, just for the arbitrators, would be $30,000. Arbitration, my opinion, is bad in oil and gas leases, because a very possible claim that you may have in an oil and gas lease may relate to how your royalties are being paid. Were you shortchanged? Were you overcharged? Was there a problem with the gas price that you were given? All of those things, royalty related. So those claims, and they can be very, very powerful, especially if a company is doing the same thing across the board and we feel that that's wrong, and they're paying, and again, in my hypothetical, they're shortchanging landowners each month $100 per acre in royalty payments. Again, I stress this is a made-up hypothetical to illustrate a point. But the problem is, again, for you as the landowner, the claim isn't big enough to take to arbitration individually because it's cost prohibitive, meaning the cost to bring the claim are too high compared to what the claim is because you don't have 1,000 acres. So companies want to force people to go individually through arbitrations because they know, first off, there's going to be a majority of people that are probably never ever going to bring a claim. So if they are taking $100 a month per acre, they're going to be able to do that forever because they're not going to be sued because the person isn't going to bring a claim. You're listening to All Things Marcellus with me, attorney Doug Clark of the Clark Law Firm. Make sure to tune in each week at this time on this station. So, okay, there's another part to this, though. So, say you go into arbitration. You say, you know what, these guys are cheating me. I am going to arbitration. I am going to be the trailblazer guy. I'm going into arbitration, and I'm going to take them on, and I'm going to prove that they have cheated me on my royalty payments, and this is going to be great. And once I win, then everyone's going to see, hey, this company's cheating, and we're going to change everything. Okay, that sounds good. It really does. It sounds good. You bring your claim. You go to arbitration. You say, hey, I have evidence. I have a case. The company is shortchanging me $100 per acre each month in my royalty payments, and they're doing it to everyone else too, but they're doing it to me. Now, your case in arbitration is not a class case. You're only going after the company by yourself. Only by yourself. And the reason why is because you have an arbitration provision in your lease, as does most people. So you can't represent, looks like, the entire class of people. You are only going after the company by yourself through the arbitration process. So let's say it worked out great. You won in arbitration. You had an award, whether it was 3 arbitrators to none or whether you had it 2 to 1 in your favor. You get an award, and those arbitrators say, yep, landowner was right, getting shortchanged, we're awarding in your favor. You say, great, not only did I win, but now I have set the standard for all the other landowners that are being taken advantage of in my hypothetical situation. Well, it's the old Lee Corso not so fast, my friend, because that arbitration decision that you're right, that the company is wrong, is called non-precedential, non-binding. What does that mean? It means that the decision that you win in that case, that you're right, that decision in arbitration does not set precedent for other arbitration cases. That victory that you had in arbitration does not set precedent for other court cases. It only applies to your single individual case. Very, very limited. Only applies to your specific case. No other future cases. So when your neighbor goes into arbitration and they say, hey, my neighbor, John Smith, he wanted arbitration. This issue has been done. Look, here it is. Those arbitrators cannot look at that. It is not binding. It's not precedential. So they're going to look at this case as a whole new case. Remember, most cases in arbitration, you appoint an arbitrator, the company appoints an arbitrator. Then there's what they call a neutral or a third arbitrator. Typically, not always, but typically the company arbitrator rules for the company. The individual landowner's arbitrator often will rule for the landowner. Not always. And often it comes down to this third neutral person. So you're going to have different arbitrators in these proceedings. You're going to get different results. So if half the arbitrations are in favor of the landowner and half are in favor of the company, well, the company just made out because they just won half the cases. Had they gone through a class action, went through a court system, and the landowners won, the landowners would win every single case. The company cannot divide and conquer. They win one case, they win them all. Companies do not like that. Thus, mandatory arbitration provisions in these leases. Here's a lease. Let me read this. You're listening to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. So let's check this arbitration. So this is from, it's from an EQT lease. An EQT lease. Many people in Pennsylvania lease the EQT. So this one is paragraph 7 under heading Governing Law and Jurisdiction. States, this agreement shall be governed by the laws of Pennsylvania. Well, that makes sense. We're in Pennsylvania. The jurisdiction for any dispute or claim under this agreement shall be the United States District Court for the, in this case, Western District of Pennsylvania, or the Court of Common Pleas in Allegheny County. Now, Allegheny County is in the Pittsburgh area. That's where Pittsburgh is located, Allegheny County. So the next part, so it says jurisdiction. Where do you bring the action? Who has jurisdiction? Here is the case. And they say, well, either two places, the federal court in Pennsylvania or the county court in Pennsylvania. Okay, maybe fair enough. All right, that makes sense. But then here you go. One more sentence, by the way. One more sentence, and this is the most important one. At lessee's, lessee being company, at lessee's sole option, any dispute or claim shall be settled by binding arbitration. I'm going to say that again. At lessee's sole option, any dispute or claim shall be settled by binding arbitration. So you bring a class action against EQT under this lease. They say, Lee Corso, not so fast, my friend. Your lease says that we, the company, at our sole option, you can't stop us. It's up to us. It's our sole option. Our sole option. They can at any time, at their sole, not any time, but their sole option that any dispute or claim shall be settled by binding arbitration. My opinion, goodbye class action. Very, very powerful term. And that's why it's there. That's why it's there. And we need to try to get it out. You're listening to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. You can give us a call, reviews, consultation, any other representation matter, 570-307-0702. We'll be right back. We got one more segment. Stay tuned. Right back after this break. Welcome back to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. We got a short segment, so let's jump right into it. So I've been talking about arbitration provisions and giving my personal strong recommendation as a general rule, but not specific advice for any particular person, to avoid arbitration provisions in oil and gas leases whenever possible. Arbitration provisions, in my opinion, are extremely favorable to the company as opposed to being favorable to the landowner, but the company and the company landman and representative will tell you, landowner, that you want an arbitration provision because it's going to be faster and cheaper and better. But in reality, the company wants the arbitration provision. If they didn't want the arbitration provision, it would not be included in their standard lease form. I read to you from the EQT lease form where it says that the jurisdiction where a lawsuit would be brought would be either in the state court of Pennsylvania, actually in the county of Allegheny in that example, or a federal court in Pennsylvania. However, the last sentence says that the lessee at the lessee's, which is the company, at company's sole option, meaning you can't stop it. It is entirely their decision. It doesn't say at lessee or lessor's option. No, it's a one-sided deal. It says that at lessee, at company's sole option, any dispute or claim shall be settled by binding arbitration. Ladies and gentlemen, I'm pretty darn confident that that provision is in there so they can avoid being sued as a class action lawsuit defendant in state or federal court, thereby forcing. So if they see a claim they don't like and they think, hey, look, there's a class action claim, well, let's move it to binding arbitration where the landowner and that class are going to have little to no chance of proceeding, thereby separating all of the individual landowners and forcing them to bring their own individual lawsuits against the company, even if the people are correct. Even if they're correct, they have to bring individual lawsuits in arbitration and pay these expensive arbitration fees. And in many cases, we'll say, those fees and the cost of going through arbitration are going to be so high that the landowner cannot reasonably bring their case. So it's a way that you can, as a company, potentially stop literally thousands of lawsuits because it's going to cost too much to bring the lawsuit. But if the landowners were able to join together into a single lawsuit on behalf of everybody, that lawsuit could be brought and could be very powerful. But if you require arbitration, there is probably, the way it looks now, little to no chance that you're able to proceed as a class. It's very smart. Remember, pull out your credit card agreements, pull out your bank agreements, your contracts, and look, they all have mandatory arbitration. Your cable company, your DirecTV, all of those have mandatory arbitration provisions. Or say things like, well, at the company's option, we can go to arbitration and there's nothing you can say about it. Why do you think that is there? Not to benefit you. Not to benefit you. So when you look at these things, and this is a classic example, and then look at this EQT lease, I talk about this. Look, this says, you get excited when you say, oh, well, okay, we can bring it into a state or local court. But no. Read further. But if the company says, nah, we're going to push you to arbitration, and you have no choice because it's at our sole option. That should tell you something. That should really tell you something. Avoid arbitration when you can. Okay, we're going to wrap this week up. I want to remind everybody, if you're not taking advantage of our websites, you should be. Go to pagasleaseattorney.com. That's pagasleaseattorney.com. Go to pipelineattorney.com. If you're presented with a pipeline agreement and you are not going to pipelineattorney.com, why not? It is free, great quality information, educational, not meant to be specific advice for anyone, but you can read, learn, understand some things. And through both websites, you can go listen to prior radio shows. This week's radio show will be up and available Monday morning, so you can check it out, and many, many, many hours of radio shows on pipelines, multi-unit well requests, so on and so on and so on. So check out pagasleaseattorney.com, pipelineattorney.com. Use the resources. Let's raise the bar. And remember, everybody, we have to stop signing bad agreements. Stop simply signing, and remember, the company landman works for the company, not you, the landowner. Have a great week, everyone. Give me a call anytime, 570-307 0702.